And the record shall now show that the jury is seated in the courtroom. All parties are present in this cause number 22-39135, an indictment styled the state of Texas versus Daryl Wayne Johnson. Thank you, ladies and gentlemen, for your patience. And we are final and jury charge that took some finalization changes, and that is all done. We are able to move forward. Do the parties wish to present any additional information, and have you finally rested state of Texas?
Yes, Your Honor.
And defense?
Rested.
Ladies and gentlemen, at this time, the parties have rested the presentation of their cases. I will now read to you the jury charge, which contains all the law applicable for your deliberations in this case. In continuing to discharge your responsibilities as jurors, you must continue to observe all the instructions previously given to you by the court. These instructions are given to you because your conduct is subject to review, the same as that of the witnesses, parties, attorneys, and myself. Please listen carefully, as I know you will, as I read this charge to you. This charge will be left with you to refer to as necessary in the deliberation. Members of the jury. The defendant stands charged by indictment with the offense of aggravated assault, alleged to have been committed in Jefferson County, Texas, on or about December 8, 2021. The defendant has entered a plea of not guilty to this indictment. Our law requires that I submit the following charge to you in this case. This charge contains all of the law necessary to enable you to reach a verdict. If any evidence was presented to raise an issue, the law on that issue must be provided to you. Definitions. So that you can better understand some of the words and terms used in this charge, the law provides the following definitions. Assault. A person commits the offense of assault if he intentionally or knowingly or recklessly caused bodily injury to another. Aggravated assault with deadly weapon. A person commits the offense of aggravated assault if he commits assault and uses or exhibits a deadly weapon during the commission of the assault. Bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon. Deadly weapon means 1, a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or 2, anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using energy generated by an explosion or burning substance, or any device readily convertible to that use. Knife. Knife means any bladed hand instrument that is capable of inflicting serious bodily injury or death by cutting or stabbing a person with the instrument. Intentionally. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. Knowingly. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Recklessly. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of, but consciously disregards, a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the defendant's standpoint. Consent as defense to assaultive conduct. A victim's effective consent or the defendant's reasonable belief that the victim consented to the defendant's conduct is a defense to prosecution of assault or aggravated assault if the conduct did not threaten or inflict serious bodily injury. Consent means assent in fact, whether express or apparent. Effective consent is not effective if induced by force, threat, or fraud. Reasonable belief means belief that would be held by an ordinary and prudent way in the same circumstances as the actor. Prior conviction or convictions affecting credibility. In this case, evidence has been introduced that one or more witnesses who testified have previously been convicted of a criminal felony offense or offenses. This law permits this evidence to be introduced only for the purpose of aiding you, if it does, for determination in passing upon the credibility of the witnesses, and you cannot consider this evidence for any other purpose. Defendant's election not to testify. Our law provides that a defendant may testify in his own behalf if he elects to do so, and this is a right given to a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. Lesser included offense instruction. Although the defendant is charged in this indictment with aggravated assault, you may find the defendant not guilty of that charged offense, but guilty of a lesser included offense. In this case, assault is a lesser included offense of the charged offense of aggravated assault. A person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another person, as previously defined in these instructions. Now, in deciding the defendant's guilt or innocence, you should first address whether the state of Texas has proved the charged offense of aggravated assault beyond a reasonable doubt. If you find the defendant guilty of aggravated assault, you should so indicate in the appropriate verdict form, and your responsibility is ended. If you all agree the state of Texas has failed to prove beyond a reasonable doubt the defendant guilty of the charged offense of aggravated assault, then you must find the defendant not guilty of that charge. If you find the defendant not guilty of aggravated assault, you should next address whether the state of Texas has proved the lesser included offense of assault. That's not what we decided upon. I believe, let me see the lawyers up here. All right, in this, I'm going to repeat this paragraph, ladies and gentlemen. In deciding the defendant's guilt or innocence, you should first address whether the state of Texas has proved the charged offense of aggravated assault beyond a reasonable doubt. If you find the defendant guilty of aggravated assault, you should so indicate in the appropriate verdict form, and then your responsibility in this guilt or innocence portion of the trial is ended. If you all agree the state of Texas has failed to prove beyond a reasonable doubt the defendant guilty of the charged offense of aggravated assault, then you must find the defendant not guilty of that charge. If you find the defendant not guilty of aggravated assault, you should then next address whether the state of Texas has proved the lesser included offense of assault. If you find the defendant guilty of that lesser included offense of assault beyond a reasonable doubt, then you should so indicate in the appropriate verdict form. If you all agree the state of Texas has failed to prove beyond a reasonable doubt the defendant guilty of the lesser included offense of assault, then you must find the defendant not guilty of that offense. Does everyone understand your options here, ladies and gentlemen? Okay. Charge. Now, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about December 8th, 2021, the defendant Darrell Wayne Johnson did then and there intentionally or knowingly or recklessly cause bodily injury to Jeremy LaShawn Arsenault, hereafter styled the complainant, by the use of a deadly weapon, namely a firearm or a knife, that in the manner of its use or intended use is capable of causing serious bodily injury or death, by striking Jeremy LaShawn Arsenault with said firearm or stabbing Jeremy LaShawn Arsenault with said knife, then you shall find the defendant guilty of the offense of aggravated assault. Unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. If you find the defendant not guilty of aggravated assault, then you should then deliberate on the issue of whether the defendant is guilty or not guilty as to the lesser offense of assault as described in these instructions. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt, after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. You have a right to consider all of the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are in this case. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. And it is improper for any juror to discuss or consider anything which they know or have learned outside of the testimony presented to you and the law contained in this charge. If a juror should discover that they have any outside information, they must not mention this information to any other juror, nor consider themselves in arriving at a verdict. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. And you must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. You cannot question the bailiff concerning the testimony of the law, nor should you discuss the case in his presence. If any question about the law develops during your deliberation, it must be reduced to writing and signed by your foreperson and then given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Any physical exhibits, and there have been some admitted into evidence, will be furnished to you by the bailiff upon your request. After the attorneys present their arguments to you, you will retire, select a foreperson, and then consider your verdict or verdicts. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during your evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case in accordance with the law and the evidence. And ladies and gentlemen, there are three options here on verdict forms. First one, we the jury find the defendant guilty of the offense of aggravated assault as charged in the indictment, a place for the foreperson to sign. Second option, we the jury find the defendant guilty of the offense of aggravated assault as charged in the indictment. Furthermore, we find the defendant guilty of the lesser included offense of assault, a place for the foreperson to sign. Finally, we, the jury, find the defendant not guilty of the offense of aggravated assault as charged in the indictment. We also find the defendant not guilty of the lesser included offense of assault, a place for the foreperson to sign. Only one verdict form can be signed. Okay. Under the rules, the state of Texas may open and close final argument. What says the state?
State of Texas will waive its right to open and reserve its right to close them.
All right, the defense may go forward with final arguments when ready, sir.
If you know that for a moment.
And on final arguments, ladies and gentlemen, the rules state that lawyers have a reasonable amount of time to make the final arguments. What they've asked me is if they get to 15 minutes, I'm going to alert them, and then we'll go from there. Okay.
Ladies and gentlemen, you have seen all the evidence, heard all the testimony. The state has taken on this case and promised that they were going to prove it to you beyond a reasonable doubt. In order to get to beyond a reasonable doubt, in order for you to move confidently in this case, it's going to require some trust. You're going to have to trust some people. You're going to have to trust Jeremy Arsenault. You're going to have to trust Detective Robichaux. And the state's going to present to you the best image that they possibly can and try to sell you that they've met their burden. But regardless of how it appears on its face, if you ask those questions, if you start to digging, if you start unraveling things, you're going to find out that it's not pretty at all. And that burden has not been met. Not at all. You got to ask the questions, the same type of questions that we asked when we were looking at this image in jury selection. You got to give it the scrutiny. You got to give this case the same type of scrutiny. You got to see the whole picture. Somebody said, we don't know where the finish line is. We don't know where it started at. We don't know all these different things that we need to make a good, rational, reasonable decision about something. What the state's going to do is try to convince you that they have a clear enough picture. But what they're going to give you is a drug-fueled, foggy haze of a situation that no reasonable conclusions can be drawn from. A mesh of imagery with so many questions. We don't know where this supposedly happened at. Did he get stabbed at a house? Was he in a car? Was he in a pasture? Was he in Beaumont? Was he in Port Arthur? These are all questions that Jeremy Arsenault has. He said he didn't know. In fact, he said he thinks he might have been unconscious. He didn't really notice he was stabbed till later. When did it happen? Was it early in the event? Was it late in the event? He doesn't know. He doesn't know. You don't know. We don't know. One thing we do know that we can say confidently is that Daryl Johnson, Jeremy Arsenault, on several different times during the day, agreed to fight. Arsenault, you heard him say, he left his apartment to go to Orange Street to confront Daryl about getting his money. 30 minutes after he'd been dropped off, he said, he went over there to go get his money. And if you don't want to give me my money, we can knuckle up. What he said. Okay. We heard testimony that later in the day, there's a witness that he again asked to fight. Let me get a warrant. Let me get a warrant. He wanted to have a one-on-one fight. They went to Pine Street and had another fight. He threw the first punch in. That's the witness that we got. Those are two situations where Arsenault and Johnson agreed to fight. And as the state pointed out in their opening arguments, that's not a crime. What we also have here is a detective with some tunnel vision. If you pay attention, I encourage you to go back and watch these videos, to deliberate and use the evidence that's at your disposal. And you're going to see that Detective Robichaux was given information in those interviews which he immediately discarded. Y'all heard me ask questions. I asked him the names of people. I asked him about a Jermaine Sias. What was his response to Jermaine Sias? I never got the full name. I couldn't find him because I never got the full name. He missed the mark on that, didn't he? He missed the mark on just about every person I asked him about. He missed the mark on statements that were clearly made. He missed the mark on a lot. Watch these videos, you'll see Jeremy Arsenault not only gave him the name Jermaine Sias, he gave him his brother's name. He has a brother named Tobias. He has a mom that works over here. He lives over in this area. But Detective Robichaux says he just didn't have enough to even go find that guy. The same guy who is accused of pulling an AK-47 on him and holding him at gunpoint through a lot of this. Never got that full name. James Mayfield was talked about a bunch. He didn't, nobody went to go talk to him. Somebody named Maine, who Jeremy Arsenault identifies as somebody who punched him in the face multiple times this same day. We couldn't find him. Couldn't go locate that guy. Robichaux said he has 20 years of street work as a police officer, 7 years as a detective. Couldn't find that guy. Also said the landlord wouldn't cooperate with him. Now, I think that's very important. That's very important, but the landlord sat right here and cooperated with me just fine, cooperated with Mr. Laird just fine. Everything he said didn't favor me. It wasn't like he was in here just spewing things in my favor. He cooperated just fine. According to him, he talked to the cops whenever they come to him. Robichaux told you he refused to cooperate. Didn't even look for a gun. No search warrant. He says he went and he knocked on a door. Nobody answered. That's it. That's my investigation. We're not going to look for a pistol. We're not going to look for AK-47. We're not going to do any of that. Don't worry about that. Just trust me. Something happened. No knife. There was no knife in the car. There was no knife asked about during the course of the interview. There was no search for it. There was no search warrant done to identify any of this. No cameras, no videos. When I asked him about that, he told you that there were no videos available. But you had just heard Miss Johnson tell you that she got a Ring camera on her front door. A Ring camera that would show you exactly the time that Jeremy Arsenault stumbled up to her house, would show you exactly the condition he was in, could show you the time that passed before then, could answer a lot of questions. He says it didn't exist. And then he said, well, she refused to bring it to him. The same way the landlord refused to cooperate. No cameras. They wore the body camera when they went to go talk to Mr. Johnson at his mama's house. Mr. Johnson gave a version of events. He described fighting Arsenault. He described fighting Arsenault a couple of times. He says he whooped his ass. That's his say. He also, on camera, denied any type of stabbing, denied having any kind of gun. And then the story gets really weird. The detectives, they don't add up with each other. They don't add up with reason. And then you got to go back to that trust issue. You got to go back and trust. Robichaux got that right. The same detective who never got the full name of Jermaine Sykes, the same detective who was asked about Chuco. I asked him about Chuco, if you remember. Said he never heard that name. If you go back and you review these videos, what you're going to see is Jeremy Arsenault telling that detective that Chuco is a Hispanic guy who threatened to stab him that day. You're going to hear the name a couple times. Robichaux said he didn't hear that. Robichaux does say that Mr. Johnson said he made a stabbing motion like this. He said he poked him. Now that happened to be off camera. Happened to be off camera before they went to search the vehicle. When the camera came back on to search the vehicle, nobody says, hey, Daryl, tell me what did you mean by that? Nobody asked about him confessing to stabbing somebody. That seems very, very, very odd. What seems even more odd is Robichaux did hear a statement very, very similar to that. Not from Mr. Johnson, though. I encourage you, go back to these videos and watch it with the scrutiny it deserves. As Arsenault laying in the hospital bed, he says, I was poked. I was poked. Robichaux, after that day, talks to Johnson at his mama's house on December the 9th. Supposedly, this is where that statement takes place. He talks to Arsenault again, 47-minute interview. Not once mentioned, we got him. He admitted to it. We're there. Not once did he say that. That's strange. And then we get to the blood in the car. Mr. Johnson, he laid out. They did have a fight. There was blood. Ms. Baker confirms that. They fought. There was blood. You look in the back of the car, there was blood. Blood, which is described by Officer Torres or Detective Torres, it wasn't a lot, but it was visible. It wasn't a lot, but it was visible. Does that sound like a crime scene where somebody got stabbed 6 times, held hostage in a car for hours, driven around town, bleeding all over the place, had blood-saturated clothes, face leaking all over the... No, the answer to that is no, it doesn't. It does sound like somebody probably got into a fight, probably got a busted eye, and was driven home in the backseat of a car. That's what makes sense. Driven home in the backseat of the car, dropped off at the apartment at around 6:30, according to Miss Bates. From 6:30 until almost 9 o'clock. 9 o'clock is when the call came in that there's some help needed at the apartment. From 6:30 to 9 o'clock. You heard Miss Baker say that Arsenault was in the backseat of that car asking to be taken to Houston. He didn't get out of the car and go straight into the apartment. He got in the car and he walked off. For 2 hours. He was gone over 2 hours, 2.5 hours. 2.5 hours. Jeremy Arsenault, who'd been cited as doing drugs that day, who's been cited as acting erratic, irrational, excited, incoherent, breaking furniture, throwing ATM, doing all this stuff, is missing for 2.5 hours. Shows up stabbed, blood-drenched clothes, injuries to the face, bleeding from the face.
15 minutes, Mr. Jefferson.
Yes, Your Honor. But the blood in the vehicle, it wasn't a lot. Just visible. Natural and reasonable inferences. Heard the judge mention that several times. Natural and reasonable inferences. A natural and reasonable inference is that Jeremy Arsenault stumbled away from that vehicle, went on with someone else, trying to find a ride to Houston, trying to find his next PCP bump, trying to do something, who knows what. And he got into a pickle. And he got stabbed, and he got beat up. It's possible that all these things that he's saying, Chuko threatened to stab him, Maine was punching him in the face, Jermaine Sias had pulled an AK-47 on him. These are all things that could have happened over a period of time, and his distorted mind has pushed them together and has laid blame on them. But what we do know is that at 6:30 p.m., he walked away from that vehicle. His clothes did not look like that. His face was not beat up like that. He had a little bit of blood, which is exactly what you would find in that car, which clearly had not been cleaned, which clearly there was no effort to cover that up. It was right there for all to see. That is reasonable doubt. That means that when it comes time to deliberate, after you go through all this evidence and you talk this over, that you're going to grab the last page that says he is not guilty of the offense of aggravated assault. And he is not guilty of the lesser included assault. Because we have reasonable inferences that Daryl Johnson did not cause him to be stabbed, that he did not leave him in the condition that these photographs show him in, that his clothes didn't look like that when he got out of his car. And the only time that he had physical altercation with Mr. Arsenault was when they consented to fight each other, which is what Arsenault was wanting to do, which is what he went there to do. Not guilty is where we end. Thank you.
State. May it please the court. Counsel.
Good afternoon. Thank y'all for being patient with us and listening to everything. I want you to notice that all I've heard is question the state's evidence, but not question anything they did or anything they say. And the reason I say that is because when you're looking at the evidence and you want the truth, you got to question everything. And so when I told you at the very first, and we started all this, we started about credibility and integrity, and his own witnesses are calling each other liars and or have totally different stories than the defendant's statement and his wife's statement. Everything is different. And so the credibility goes both ways. If they testify, you get to test their credibility. Second thing is I told you at the very beginning of all this in my opening statement that there was going to be two different stories. Do you remember I told you there's two different stories? There's the story that Jeremy had where he says, you owe me money. And there's the story that this defendant over here, and yes, I'm calling him a defendant because that's what he's calling the indictment, the defendant. There's a statement by him when it first begins. Remember when it opens up, he doesn't say, yeah, we were moving that morning, did he? No, he started off with, this began way back. These people that he's hanging with were they have a problem with me since high school. They were trying to kill me. Two different stories, two different versions of things going through that day. And they all agree on certain things, but the perception is different. Even the landlord says whenever Jeremy came over there to get something, yes, he was upset. He wants his money, but he wasn't irrational. They kept trying to get him to say it. He was irrational, wasn't he? Oh, no. He looked like they were having some kind of argument, and he was a little upset, but he wasn't irrational. And what did the landlord say he did after they got through with this little argument? What did he say Jeremy did? The one person who doesn't have a dog in this fight. What did Jeremy do? Jeremy was walking away down the street, and the defendant got in a car and drove after him and kept trying to get him and finally got him in the car and then drove up. That's the last he saw him. That doesn't fit his statement, doesn't fit his wife's statement about how all this stuff happened. He was irrational and everything, and then he hugged him and kissed him and all this stuff. That's just silly. Do you really believe that? And then when you go through the day, he's taking him home, people. He's been moving. They're moving. They're trying to get this girl in here. They've got other things going on. They've taken the U-Haul truck back, but they've still got stuff to do. I'm taking him home. 5 hours, even by their own admission, for 5 hours they're together. Why? That's why it's important for you to listen to the defendant's statement too. You can listen to Jeremy's statement. Listen to him. Jeremy, you won't have one time having him say he considered being beat all up like this and stabbed. Not one time. But you're going to listen to this man's statement when he starts off with, they were trying to kill me. And he was hanging with them. And he showed up over there with Wingate. Wingate shows up over at my house. And you know what? I know he's that part of that people that are trying to kill me. So he gets him in the car and he starts taking him. And you remember every time he took him somewhere, he said, this is that friend I was talking about that's involved in that stuff. Listen to his statement. What do you think he's doing? He's taking him over there. He's not giving the cops names. He's the one that could clear it all up. He's the one who knew the addresses. They were his friends. He said, I don't get them involved. They didn't do nothing. It was all my fault. I take full responsibility. But they keep saying this guy who got beat up by Roberts Park. And I mean beat up, people. He said it in the video. You listen to his words. I kicked his ass. That's what he said. And you know what's funny about all that? All this beating he did and all this fighting he did, not one time does he show a mark on his hands where he was hitting him with his fists. All he's got to do is go, officers, look, my knuckles are swollen, they're red, they're hurt, they're skinned up, whatever. I beat him. Look how bad I beat him. He had a fractured orbital socket. His eyes were swollen shut. The muscle was stuck in there because I hit him so hard, and yet there's not a mark on my hand. But everybody took him. Where? Look at this. This is the guy. You heard him say it in his statement. This is the guy. He's with those people. They try to make him out to be, they talk about, oh, this guy Citizen? Yes, he is a citizen. But so is the guy that got stabbed, whether he runs around naked because he's on PCP. That doesn't make him a violent person. Did you ever hear the police officer say, I had to fight him every time? No, they said I had to chase him naked down the street, and then I'd lock him up and go get him sobered up and he'd be okay. And even he called him a passive aggressive. And he said when they got out to the park, he just hit him in the chest. He goes, he was playing. I wasn't playing, I'm a grown man. That man right there took advantage of Jeremy Arsenault. He calls him up because he knows he's an easy. And then when he saw him with Wingate, his little mind clicked. Maybe he was on something. I don't know. I can't tell you that for sure. And I'm not even going to try to prove it. All I'm going to say is this, is you could tell from his statement with the police, there was something that was wrong with him that day. Because he starts off with, this didn't begin that day. This began years ago. And then he starts going through talking about how he took him to every place Jeremy said. Y'all got to remember, Jeremy, his incoherent mind, doesn't know the addresses, but he knows he took him to this place over by Roberts Street. Then he went to this other place, to the store. Remember he said he went to the store. Even the wife said he went to the store and showed him to some more people. They went to all these different places instead of just taking him home. I had access. He could have got the card from White, got him some money, and sent him home. 5 hours. 5 hours. Forget about the 2 hours. There's no proof of that. That's his wife's statement. There's no proof that he was let off him. Matter of fact, his wife said, Jeremy's wife says, guess what I was doing with him when they dropped him off? I'm over here by the dumpster. I'm trying to get home. He walks in, she's talking to him on the phone the whole time. There's no proof of any of this other than he said, I took him everywhere. I kept showing him these people. This is the guy's trying to kill me. Not a mark on his hand. So how did he get all this? There's not a mark on his hands. Unless, imagine this, unless those reasonable inferences say, if he doesn't have a mark on his hands, he must have been using something to hit him with. Wow. And to fracture an orbital socket, do y'all realize how hard that bone is on your skull? To fracture that and to cause that damage where the muscle's trapped in there and there's pressure from behind the eye because you're hit so hard and the little dings in his head, the little scratches and things don't come from fists, they come from something, and a metal hitting him in the head. Gun, fighting him, hitting him. And where in the world would a man who's trying to make up a story, why wouldn't he just say they just stabbed me or beat me? Where in the world did a stripper pole come from? And you're making this story up while you're laying there on painkillers in a hospital bed. Shortly after you got there, they've been putting staples in you, working on you, and you've come up with this story that actually matches his story, except it adds something to it. Make me grab it, wrap my legs around it, and he's beating me in the head. And he doesn't know when he got stabbed. Because he's got so much pain going on, so much going on around his body, that it's hard to tell when something else happens. And yet not a mark. All these fights they had, he has no mark. Not one. So why do their stories add up so much? If Jeremy's a liar. And why is it that when he's talking to the police, the defendant, when he's talking to the police, and he's the one who's driving, and they are his friends, he even tells you, they are my friends, they can clear him. They didn't do anything wrong. If they did nothing wrong, and he did nothing wrong with those homes, if there was no beating, if there was no gun, if there was no knife, if there was no bashing in the head, if there was no stripper pole, all this man had to do was, here they are. These are the addresses we went to, because I drove. Why can't we ask that question? That wasn't asked up there, was it? I'm not trying to sell you anything. I'm going through what the evidence shows. You go through and match these up. Everything Jeremy says, this man says, it's just in a different way. And it sheds light for him, but he won't tell them. And they have every right to say, I looked up the ones that Jeremy gave me, but Jeremy's the one being beaten, guys. Jeremy's the one that's got all the injuries. He didn't have a single mark on him. He claims he was completely sober, didn't have anything. He could have told them every little thing. And then we get to this part about, well, Detective Torres says, let me tell you something. Defense attorney's doing a good job. And he had him convinced because he put in his report that we were standing by the Venza. Remember, Detective Torres looked and said, standing by the Venza whenever I heard him say that, so it must have been before. Remember that? And he goes, why didn't they ask you when they turned the video back on? Well, then you listen to Torres. And you heard Torres say that the Venza was parked up by the gate and they were walking around and they stopped right there by the Venza before they got out the gate to leave. And that's when he said it. So they're both right. They were standing by the Venza. He just convinced him that it happened before. And it was 4 years ago. You can convince people of something when you look at a report and you read it a certain way and they go, well, I guess you could be that way. But Robichaux remembers that Venza was parked over there by that where they were fixing to leave and they were right by the Venza. But both of them, in his report and in Robichaux's report, both said they were standing by the Venza when he made that. And you don't think the detectives, if they'd have had him beforehand, would have said, hey, what'd you just tell us? And he would have denied it or whatever. But he made sure that they were done, they were leaving. He goes, okay, it's the camera off. Because I don't want to admit this on camera. But I poked him a few times. And he did this. And you know why it's important? Because he just said it a while ago. Jeremy in the hospital said he stabbed me while I was in the back of the car. Said, I think he poked me because he had that knife back there against me. And the whole time he's talking about this man laying down in the back of the car, just like Jeremy said, told him to hug that little safe or whatever it was down the bottom floorboard, and he's holding on to it. And he said, I didn't trust him. You think he's just going to leave him back there without having something to keep him, protect himself from him, or do something if he doesn't trust him? And the blood, you know why the blood wasn't all over the car? Because it was soaking up in here. Those stab wounds were bleeding, but they weren't bleeding profusely because the doctor said, you remember what he said? Those 4 stab wounds are clear. He just put staples in them. It wasn't like it was gushing all over the place. You know, get this image of people. He would have died. He was gushing all over the place. But if he was stabbed and he was eating where he filled up his clothes, it would have soaked up in the clothes. And some of it would have got in the car. And you got to remember, this is also the next day. So we don't know if he tried to clean some of it up and he just left some because he couldn't get it all out. But the reasonable inferences of this, guys, listen to the story that he tells. This is the reason why he did it. It's because he thought that Jeremy was trying to act with those people to come after him. And that's why he told Detective Robichaux, I did it because he's with those guys who were trying to kill me. I was defending myself. And that's not self-defense. You don't see that anywhere in a court's charge because that's not how self-defense works. Self-defense works when you're immediately defending yourself against something that's imminently coming at you. You can't just stab somebody because you think they may be with some other group. His story doesn't make sense. It doesn't make any sense unless you add it to Jeremy's. And then when Jeremy talks about it, then you realize why he didn't just take him home and they spent 5 hours together, because he was trying to get information out of him. Listen to his statement, because he said, each place we went, he talked more. He gave me more information. Each place we went, remember the blah, 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 but he goes, each place we went, he gave me more information. Why? Because this man right over here was torturing Jeremy Arsenault to try to get the information out of him. He was torturing Jeremy Arsenault to try to get him to admit these people were trying to kill him. But poor Jeremy Arsenault just wanted his money. Because he hadn't been able to do anything for the people that have been supporting him. Call him what you want. But all those convictions and all those things that they brought up about him is drugs. Yes, he uses drugs. Yes, he admitted to using drugs. Yes, he admitted going to prison. But not one time did you ever hear anybody say, Jeremy Arsenault's a danger. He's just naked and runs down the street. He doesn't fight people. Not even the cops when they caught him. They never one time said, yeah, we always had to fight him. He was always violent. So don't buy into this story about, oh, he must have walked off after we dropped him off at the apartment complex and somebody else beat him senseless and stabbed him and then brought him back, or he staggered his way back home. That just doesn't make sense. His wife was on the phone with him until he got there. The kids were screaming. They got him to the hospital. He didn't want to go because this guy right here scares him. And if you were treated like that and beaten like that, you got to remember this. This is not just a beating in the front. This is where he said he got hit with the pistol on the back of the head. All the little dents, the stab wounds. Everything adds up to what Jeremy said. He can't tell you details of where they were. He can't tell you details because that man prevented him from it by hurting him so bad. All I could do is try to stay conscious and try to stay alive. Don't buy into that story. Go back there and look at this stuff. Reason it out and find out that the reason you find him guilty is because of his mindset and the way he started out that whole statement. This didn't begin that day, it began years before. And that's his motive. I look forward to your verdict.
Ladies and gentlemen of the jury, at this time, I am tendering the jury charge to the bailiff. I'm going to ask the jury to please step down from the jury box, follow the bailiff into the deliberation room. We will await your verdict. The alternates, again, by rule, only 12 jurors are allowed in the jury room. We're going to ask you to be so kind to hold vigil out there. Sometimes we replace even during deliberations. So thank you for your patience and your citizenship. Thank you. And you're excused and stay close by and we'll keep you updated with everything. Thank you. The jury is now in the courtroom. The record shall show all parties are present. Mr. Rosenthal, you are the jury foreperson. We have received a message from the jury on your behalf that the jury has reached a verdict in this case. Is that so, sir?
Yes.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury.
Yes.
Do any of the jurors disagree with your foreperson's representations? No disagreement. It does indeed appear to be unanimous. I'm going to ask you, please pass the documents to the bailiff. You may be seated. The court will review for proper form and publish the verdict. The defendant shall rise. In cause number 22-39135, the state of Texas versus Darrell Wayne Johnson, we, the jury, find the defendant guilty of the offense of aggravated assault as charged in the indictment signed by the jury foreperson. The verdict is received. It is made a part of the record for all purposes, and you may be seated. Ladies and gentlemen of the jury, at this time, I have received your verdict, finding the defendant guilty of the offense as charged, the second-degree felony of aggravated assault. And that brings us to a close of this first phase of this bifurcated trial. We will now proceed with the punishment phase. And once again, let me repeat, you are under all the instructions previously given to you. Let me see the lawyers, please. Thank you.